Coming up on Lawmakers, the House votes to outlaw marriage for anyone under the age of 16. The Senate gives the final nod to Governor Perdue's 65% solution for public schools. And proponents say it's a victory for property owners. A Senate committee exempts certain development from a 150-foot stream buffer zone. Those stories and more are coming up next.
This is Lawmakers, your source for all the news from under the Gold Dome. Here are your anchors, Gerald Bryant and Wandy Lawson.
Good evening, everyone. Also on Lawmakers, a House committee paves the way for Governor Perdue's faith-based funding initiative.
And the Senate passes a bill that would outlaw animal fighting and baiting, but our lead story tonight, teenage marriage may be getting tougher. Legislation that prevents anyone under the age of 16 from getting married in Georgia passed the House today. Under current law, children under 16 can get marriage licenses if they're pregnant. David Zelski joins us live from the Capitol with more about the passage of the bill. David.
Well, and Wandy, Representative Bobby Franklin sponsors House Bill 1023 and has received bipartisan support. He says Georgia is one of only 3 states where someone pregnant and under 16 can still marry without parental consent.
We were embarrassed earlier last year when a 15-year-old child was able to marry his 35-year-old, the 35-year-old mother of one of his close friends because of a loophole in Georgia's marriage law that allows someone, when pregnancy is involved, to bypass parental permission if they're underage. What House Bill 1023 does is it closes that marriage exception loophole. It strengthens the family. It says that you've got to have parental permission if you're 16 or 17. If you can't get your parents' permission, then there's a provision where you can petition the court, and the court hear testimony from parents, guardians, other interested persons, and if the court determines that it's in the child's best interest to allow the marriage, then the marriage can proceed.
Representative Randall Mangum offered an amendment to allow a couple under 16 to marry if the girl is pregnant and has parental consent. This attempt led to a challenge of his fellow House members.
If you are honest with yourselves, how many of you can say today that you didn't have sex under the age of 16? How many of you, I challenge you today, some of you tell the truth and shame the devil today. That if you told the truth, if you were under the age of 16.
Chairman, suspend a minute.
Now, the Mangum amendment failed, but House Bill 1023 passed by a vote of 127 to 47 and now goes to the Senate. Reporting live, I'm David Zelski for Lawmakers.
In other news, Governor Sonny Perdue's 65% solution bill requiring local school districts to spend 65% of funds in the classroom got final legislative approval today in the state Senate. Senator Ronnie Chance explained that the House had added some additional waiver provisions and changed some language.
The third change in the bill has to do with classroom-related activities and definitions, which I know we talked about here in this chamber. The word athletics has been struck and replaced with the words physical education, as it is improper to use school funds for extracurricular or interscholastic athletic purposes other than those specifically enumerated in the Constitution and statute.
Senator Michael Meyer von Bremen was among Democrats who referred to an Atlanta Journal-Constitution article quoting a study questioning the effectiveness of such legislation.
Have you read that article? It's a Standard & Poor's study?
No, sir, I have not read the article today. I am familiar with the study, though.
Will the gentleman further yield?
Yes, sir.
Would it be prudent on our part to defer this until we've had a time to analyze the Standard & Poor's study, which has shown 2 cases that I just read about that demonstrated that it did not increase proficiency on the passing of the math, one in one county and one in the other, where one county spent the requisite 65%, and they scored lower proficiency, and the other county spent below it, and they scored higher. Would it not be worthwhile for us to be able to have time to digest this study and see if we need to backtrack and wait a minute?
Not in my opinion, Senator. I appreciate you bringing that to my attention. What we're talking about here is student achievement, and statistically, consistently, the school systems that spend 65% or higher in the classroom have higher SAT scores and higher CRCT scores. 77 points higher on the SAT.
The Senate approved the House changes to Senate Bill 390 by a vote of 33 to 19, and the bill goes to the governor.
The House Human Relations and Aging Committee gave a due pass to legislation today that allows religious and faith-based organizations to receive public funding for social services. Some opponents believe this measure would enable public funds to go to private schools in the form of vouchers. However, supporters say this measure simply puts Georgia in line with the U.S. Constitution and helps avoid lawsuits.
Shall the Constitution of Georgia be amended in a manner consistent with the United States Constitution, so as to prevent discrimination in the public funding of social services by allowing religious or faith-based organizations to receive public aid directly or indirectly for the provision of such services.
Representative Jeanette Jameson presented a substitute that offered extra protections against vouchers for private schools. However, the substitute failed 3-4.
The paragraph C, no public funds provided pursuant to this paragraph shall be used to pay tuition or other expenses at any private, religious, or parochial school from kindergarten through grade 12 education. So what I'm trying to do in the substitute to House Resolution 1345 is to simply put in language what we've said here today does not exist.
Representative John Lunsford was brought into the committee today to serve as the needed majority vote to pass that bill 4-3 in his role as the House hawk in that committee. If House Resolution 1345 passes with a 2/3 vote in both the House and Senate, it will then be a referendum issue at the polls in July.
Today, the Senate Natural Resources Committee gave a due pass to a bill that would permit building within some state-imposed stream buffers. Single-family homes would be excluded from buffer restrictions over 50 feet. Lawmakers Jesse Freeman joins us live from the Capitol with more on that story. Jesse.
Well, Gerald, Senator Chip Pearson sponsors Senate Bill 510. He says some of his constituents' rights are being compromised by stream buffers set by the Environmental Protection Division. Nearly 100 North Georgia residents made the trip to the Capitol today for the committee vote. Environmental groups say building near streams rises sediment level and causes pollution. But some North Georgia property owners say buffers encroach upon their rights. Over the past week, both sides have made their case at rallies and in the Senate Natural Resources Committee.
It's not the state regulations here that are the problem. Those are in place to help protect our drinking water supplies, which we believe to be very important, and we do not think that that law should be changed.
If you pass legislation that forces me to give up my creek, it means I can't raise hay down there in the most arable land I've got.
Last week, speakers at the committee meeting were heavily opposed to SB 510. Today, input was more balanced.
This is a bill that we think local governments can work with, and the processes that are put in place in this are reasonable.
We do think that there ought to be reasonable variances and so forth, but let's keep those buffers in place.
If there are serious environmental concerns to be addressed on the stormwater management, I'm sure Senator Pearson is willing to look at, fine-tuning some of the language. However, an overall concept and purpose, ACCG is proud to support this legislation.
The committee substitute to SB 510 passed 5-2. Conservation groups believe there's still work to be done.
We think the single-family houses ought to be subject to the same variance provision that is also in the bill. Have the same concern or a similar sort of concern about the exemption for a floodplain management ordinance. We do not see how a floodplain management ordinance can be drafted that will provide the same effect on water quality as would the buffers.
Now, in addition to the single-family home exemption, developers would be able to apply for a variance to build within the EPD buffers. The EPD would decide whether or not to grant that variance. Reporting live, I'm Jesse Freeman for Lawmakers.
The state Senate today voted to toughen the state's DUI laws. Senator Bill Hamrick says too many DUI cases are being overturned in the courts because the current statutes are too vague.
Currently, the Supreme Court has said that you cannot get any evidence if they refuse the test. This bill will allow law enforcement to get a warrant just as they can in any other case following constitutional procedures to gather evidence. And that case actually resulted from a situation in my district where a conviction was overturned on a drunk driver who was under the influence of meth, actually, who killed a grandmother and her son, and his conviction was overturned because he refused the test. Then the law enforcement officer said, well, we'll get a warrant for the test, and then he consented, and so the Supreme Court threw it out saying that no warrant would be obtainable. So this clears that up in the law.
It also allows for a per se DUI violation similar to a per se violation if you have 0.08 alcohol in your blood. Currently, that's a per se violation. This adds that if you have heroin or LSD in your blood, that is a per se violation, and you can be convicted of driving under the influence based on that presence of those drugs.
The DUI measure, Senate Bill 502, passed 51-1 and goes to the Georgia House.
An attempt to amend the Georgia Civil Practice Act to allow plaintiffs an opportunity to refile court papers failed to pass the House today. Supporters of House Bill 1195 said it would keep plaintiffs in civil suits from having their cases dismissed due to inaccurately completed forms. But opponents claim that the measure was intended to protect irresponsible attorneys. First bill sponsor Wendell Willard.
Many times a lawyer is not going to even have a client come into the office until maybe a few days prior to the running of a statute of limitations. Regretfully, it happens all the time. And when that happens, if you have this case being filed, and maybe the lawyer sends it down with someone from his staff to get it filed, and leaves it there, and then the clerk gets ready to take the file and do the processing, and all of a sudden, well, we don't have the form, so we can't take it. We'll put it in an envelope, send it back to the lawyer, and say you got to bring your form in. In the meantime, the statute of limitations has expired. Who's punished? Who is the one that is really going to be punished when the statute of limitations expires? Now, the lawyer may ultimately get punished, but there's a long process to go through a what we call a legal malpractice case, and a lot of expense involved. The one that's really to be punished in that situation is the party, the client, the individual.
How many of y'all like BLTs, bacon, lettuce, tomato sandwich? I enjoy a good bacon, lettuce, and tomato sandwich from time to time. Well, I'm going to tell you something. This bill we're about to vote on is not a BLT, it's a BLB. That's a bad lawyer bill. And what it does is it allows a lawyer to fill these forms out incorrectly and not be held accountable by anyone. Under the current law, you have to fill them out correctly. You're held accountable. What this bill does, it creates a loophole for the attorney to fill the form out incorrectly or to not fill it out at all. And I would say to you that if you're an attorney and you can't fill this out correctly, I wouldn't want you to be my attorney.
By a vote of 73 to 86, HB 1195 failed to pass the House. Representative Wendell Willard says he will ask the House to reconsider its action when the General Assembly reconvenes next Tuesday.
The Animal Fighting Act, which would aid law enforcement when prosecuting dog fighting, was passed by the Senate today, but not before legislators had a spirited debate about how legal animal gaming would be affected. Lawmakers Lauren Brown is standing by live at the Capitol with more. Lauren.
During this morning's debate on the substitute to Senate Bill 229, the Animal Rights Act, the focus unexpectedly moved from dogs to chickens.
You know, it seems logical that if you were against dog fighting, that the poultry, you would be against that.
In going through this process, some of the things I did learn is that you must train dogs to fight each other. They don't normally fight each other in just a normal situation without training. My understanding is certain breeds of chickens will fight each other with no training. So I understand some of their issue is that you're outlawing something that is a normal occurrence among these birds if they're placed together.
At present, cockfighting has only been ruled illegal in case law and is not a part of the official Georgia annotated code. In addition, some Georgia poultry producers ship chickens to areas of the world where cockfighting is legal. Still, Senator Steen Miles felt Georgians should have no part in animal fighting of any kind.
My amendment is very simple. It adds language that prevents cockfighting as well in the state of Georgia. This is not something that we should be known for. I do have a dog in that fight, and besides that, it is just wrong, pure and simple.
The floor amendment passed the Senate by a vote of 32 to 12, and the amended legislation will head to the House. Reporting live for Lawmakers, I'm Lauren Brown.
In other Senate action, the Senate today passed two bills aimed at protecting Georgian cell phone records. Senator John Weil says that under current law, it's easy and fairly cheap to find out what should be private information.
Your cell phone records are available on the internet for a mere $99. You can, if someone has your name and your cell phone number, they can pay $99, and within 8 hours, They'll get this company or companies will give you the last 100 phone calls that you made on your cell phone. And I said, well, that's got to be against the law. That's not right. Well, turns out it's not against the law in Georgia. Everybody thinks your cell phone records are private records, they're your private information, but it turns out it's not against the law. And that's what this bill does. This bill says you cannot go and sell someone's cell phone records.
Senate Bill 456, making it illegal to sell cell phone records, passed 55-1. Also passed was a companion measure providing penalties for those to attempt to sell your private information. Here's Senator David Schaefer responding to questions from Senator Ed Harbison.
This bill allows private detectives and security agencies to be disciplined, to lose their licenses if they violate this, any of the provisions of this act.
So legally they cannot obtain the records?
They cannot under this bill, and further they can lose their license in addition to the other penalties of this bill if they were to attempt to obtain that information.
Senate Bill 455 passed with one dissenting vote. Both phone privacy measures are headed for the House.
The House today voted to add parents to the list of advocates who can assist in determining the mental competence of a juvenile defendant. Representative David Ralston presented House Bill 1145.
Currently, under the law, the judge, the prosecuting attorney, the guardian ad litem, and the child's attorney are the only persons who may have the potential to raise incompetence as an issue. This bill simply adds parents to the list of people who can raise the issue of competence. Secondly, every year our Department of Juvenile Justice is charged with serving children who are moderately to profoundly retarded by placing them in our detention facilities. Many of these young people never had an attorney in the court process to protect their rights or to raise the issue of competence. With this bill, if it is passed and becomes law, then that potential will be eliminated because the court will appoint an attorney to represent children anytime the issue of incompetence of the child is raised.
The measure passed 144-1 and moves to the Senate. The House also agreed to allow private companies to administer cosmetology licensing exams. The bill sponsor told the House that the state is no longer able to test all applicants.
The problem right now is that the amount of testing, the amount of applicants has outgrown the testing process that the board has. I mean, it's outgrown state government, basically. So they've gotten behind, and what this will do is to provide that people can get their testing done on a timely basis and get it back to them, get their licenses. However, there will be an increase, and I believe the cost for the examination with the private company, I want to say I think it's $89 is what I've been told.
House Bill 1170 passed without opposition. It moves to the Senate. The House also agreed to Senate changes to a bill creating a commission to select artwork for the Capitol. Final passage of House Bill 978 sends it to the governor for his signature.
Well, it's time for our weekly conversation with one of our favorite journalists. Tom Crawford, the national editor of CapitolImpact.com, says one of the legislature's most experienced members is calling it quits.
Terry Coleman, who was the Speaker of the House for 2 years, Gerald, and before that, the Chairman of the House Appropriations Committee, right now the senior member of the House with 34 years service, has decided he's not going to run for another term. A lot of folks around here know Terry, of course. He's had a big influence on what's happened at the Capitol over the last 15 or 20 years. It's a very significant loss of experience, institutional memory, a lot of the qualities that can be helpful when you've got as many new members of the General Assembly as you do now. So I think it's fair to say he'll be missed, and he did a lot for the state in his time here.
Yes, and it may be just a mark of how long I've been around here. I didn't think of Mr. Coleman as having been that senior here, but 34 years is a long time in the Georgia General Assembly.
Very long.
Let's get around some of the issues they did address in the three-day week. One of them is this morning they did the final disposition of the 65% solution bill. Tell us about that, Tom.
That's the governor's bill that specifies local school systems have to spend at least 65% of their money each year on teacher salaries, expenses related to the classrooms. It's going to be, I think, a hot issue on the political trail this year because a lot of local school officials are very unhappy with it. They don't like the idea of the state exercising that much control over the money they spend, so this will cause a lot of talk between now and November.
And Democrats are quoting a relatively new Standard & Poor's report that was in the Atlanta Journal-Constitution today, saying that the 65% solution they don't believe is a solution at all.
That's right. They crunched the numbers, and they said that just because you spend 65% or more of your budget on the classroom activities doesn't always translate into better performance or better test scores.
There were some other issues that didn't come up for a vote, but have had pretty extensive public hearings, one of those being public hearings on immigration.
That's right. There was a major hearing on Senator Chip Rogers' immigration bill earlier this week. There will be another major hearing on it Monday, and I believe we'll get a floor vote in the Senate on it sometime next week. So that's another one that will have a very big impact on the state's immigrant population.
One thing I noticed this week, Tom, and these are issues that crop up periodically, a lot of ink and a lot of television time being given to Senator Vincent Fort and his dope candy bill. And I just wondered about your observations on issues like this that will just kind of bubble up and suddenly have a life of their own.
Well, when you have a lot of people who don't have a lot of things to do or a lot of things to fill their time with, you get legislation like that. And remember, it's also an election year, so it's a good time to start beating the drum for whatever your issue is.
I think it's interesting to notice, too, that most of us bite on that, too, because I've seen a lot of newspaper, television, radio coverage, and I think even some national coverage on that issue.
That's right, and why it catches the popular imagination is a mystery I've never been able to solve, but there you are.
Tom Crawford from CapitalImpact.com. Thanks for joining us on Lawmakers, Tom.
Always a pleasure.
Senator Vincent Fort held a press conference today announcing the filing of a moratorium on the death penalty. Craig Whitley has more on that story.
Senator Fort announced two pieces of legislation today in order to put together a committee to study the death penalty and to put the death penalty on hold. He cited a report by the American Bar Association.
The American Bar Association's report on the application of the death penalty in Georgia. This document right here gives us better information than we've ever had. It gives us new information, and it updates information that we've either had before or that we had implications about.
Since 1996, we have executed 19 individuals who were placed on death row, but 22 individuals who were on death row have had their sentences reversed in post-conviction proceedings.
Georgia is the only state that does not provide attorneys for people who are already under a death sentence and on death row once the first appeal is over. Every other state in the union provides counsel for people to investigate these cases and present any issues that are there. Without a lawyer, somebody who's on death row is relying upon either the goodwill of volunteers or else will just go unrepresented.
We're just saying, can't we take out a time out in Georgia to examine these problems and these biases so that we can make sure that no innocent person is executed under our watch?
Reporting for Lawmakers, I'm Craig Whitley.
In other news, a bill that would institute a sentence of life in prison without parole for anyone committing murder who has previously committed 3 felonies received a due pass from a House Judiciary non-civil subcommittee this morning. This measure would close a loophole in Georgia's 3 strikes and you're out statute. Representative Tim Bearden presents Senate Bill 57.
What this would allow on a capital offense for a person to be sentenced with life without parole. Right now, under current law, a person who has 3 prior felony convictions and who then is convicted of a 4th felony must serve a maximum time provided in the sentence without parole, except for capital felonies. Now, this would be your murder.
The subcommittee also gave a due pass to a bill that would eliminate dual psychiatric evaluations for people pleading not guilty by reason of insanity. Senator Seth Harp explains this bill.
The present law requires the Department of Human Resources and the Department of Corrections both are required to do psychiatric evaluations. Senate Bill 398 eliminates that dual requirement. It's somewhat of a housekeeping bill that simply eliminates this dual requirement and this dual expense of 2 psychiatric evaluations in a criminal case.
Both of these bills will now move to the full non-civil committee, rather. Today was Disability Day at the Capitol. Over 1,000 people arrived from all over Georgia to show their support.
Families and advocates gathered at the Capitol today and honored one of their own.
we could think of no other person better to receive the first Outstanding Self-Advocate of the Year award than Mark Johnson.
It's really special. My family and I have been in Georgia for almost 20 years, and more and more people are getting involved, more and more people are creating change, and it just feels good to be recognized by your colleagues. But what is really special about it is they make you look good, so they make me look good.
We've come here today to tell our legislators that our vote counts. We vote! We vote! MFP! MFP! We vote! We vote! Unlock the waiting list!
The group then made their way to the depot for a luncheon.
Medicaid programs like the Katie Beckett waiver, the mental retardation waiver, the independent care waiver, all those programs are very important. Our goal is for our children to grow up and become independent, tax-paying citizens, but they need the support now.
It's great to see the members of the disabled community working and paying taxes every day in Albany, Georgia. I know if we can do it in Albany, we can do it all across the state of Georgia.
I just asked Jeff Brown as I walked up here. I said, Jeff, how many positions are we going to be able to unlock on the waiting list this year? And he says, and I commit to do what he says, we're going to try to get to the 1,500. We're going to do our dead level best.
Reporting for Lawmakers, I'm Matt Rasnick.
Well, the House today honored the 50-plus year career of fiddlin' Howard Cunningham, and as a reward was treated to some foot-stomping tunes. Not a bad way to start the day. Lawmakers will not be seen tomorrow or Monday because the Georgia General Assembly will be in recess. We'll return with all the latest from under the Gold Dome Tuesday night at 7. If you've missed any part of this Lawmakers broadcast, tune in tomorrow morning when Lawmakers repeats at 5:30 a.m. Now stay tuned for Prep Sports Plus. That's coming up next here on GPB.
Haven't seen that much agreement in the House in 15 years. That's our broadcast for this, the 23rd legislative day of the Georgia General Assembly. I'm Gerald Bryant.
And I've been Wandy Lawson. Thanks for joining us. Have a great evening. Good night.
Production of Georgia Public Broadcasting.